I'm Johan Erasmus, a director at Deliotte. In terms of the Companies Act, the directors have to manage the company, and the Act specifically says that the directors have all the authority needed to manage the business, except if that authority is limited by the Memorandum of Incorporation. Now, what is important here is that you make sure that the directors are appointed correctly, and the Act specifically says that directors can either be appointed ex officio or they can be appointed by a person identified in the Memorandum of Incorporation, like a shareholder, so the shareholder representative, and then lastly directors must be elected. But only the members that are appointed to the board are deemed to be directors of the company. The Companies Act set the standard very high for the conduct of directors. It codifies the fiduciary duty and the duty of care and skill that we know in common law, and now requires directors and prescribed officers to always act in good faith for a proper purpose in the best interest of the company, and you have to apply the care, skill and diligence that can reasonably be expected of someone that has your skill and experience. So that's the standard at which you have to operate. Now, the consequence for not meeting the standard is personal liability. So if the company suffers loss or damage because a director did not meet the standard of conduct, that director can incur personal liability. In addition to the codified standard of directors' conduct, the Act also codifies the business judgment rule. Now, the business judgment rule can be used as a defense where it is claimed that the director did not meet the standard of conduct and as a consequence the company suffered loss or damage. Now, the business judgment rule requires a director to show that they applied their mind. In other words, they became familiar with all the information pertaining to a particular decision, that he or she does not have a personal conflict of interest, and if they do, that they have declared that, and that they had a rational basis to take a decision at a specific point in time. In other words, at the time when they took the decision, they believed it was in the best interest of the company. Now, where a director can show these three things, then that can be used as a defense in case of a liability claim. It is really important for companies to take the Companies Act seriously, because this is the document that would tell you exactly how you should operate, what you're entitled to do, and what the consequences are if you do not comply with the provisions of the Companies Act. Just from a personal point of view, the Act says that if any person suffers loss or damage as a result of any other person not complying with the provisions of the Act, that person can be held personally liable.